Slam dunk, are you ready to meet me? I'm lit and I'm riding the fast lane. Don't let me down, I'm on fire. Does anyone else feel like a liar? It's all in your head and right. You just never use it.
It is with great honor and privilege that I present Justice Nicholas Sampson from Neinstein, Justice Suzanne Rabb from Pacific Medical Law, Justice John Hunter from BLG, Justice Tara Sweeney from Soloway Wright, and Justice Dr. Scott Marsland, RN from the Sunrise Prevention and Early Treatment. On October 19th, 2021, after battling COVID-19 for 18 days, Kyla Stark died in the ICU ward of Fallview Health, 13 hours after her transfer from West Valley Memorial Hospital. Ms. Stark's medical records reveal she was in perfect health and she had no previous existing medical conditions, nor any prior family medical history that would indicate otherwise. She was double vaccinated as of August 1st, 2021. On October 1st, 2021, Ms. Stark tested positive for COVID-19 and contacted her longtime physician, Dr. Sophia Strange, and obtained a prescription for ivermectin. Though all pharmacies in her area were out of stock, Ms. Stark's condition was stable. On October 5th, Ms. Stark was notified that her local pharmacy had just stocked ivermectin and her prescription could be filled. But that same day, Ms. Stark had developed severe shortness of breath and mild hypoxia and was admitted to the defendant's hospital, where she was placed under the care of Dr. Myrtle Papadopoulos, a third-year medical resident. Ms. Stark immediately requested Dr. Papadopoulos administer the ivermectin her family physician had prescribed, a course of treatment which he chose to reject. On October 6th, Ms. Stark was moved into the ICU and placed on a nasal cannula during the day and a BiPAP at night. Ms. Stark was treated with the hospital's COVID-19 protocol, which consisted of dexamethasone and pure oxygen. On October 7th, ivermectin was administered after Ms. Stark's family pleaded with Dr. Papadopoulos. Within 11 hours, Ms. Stark's condition had improved greatly. However, the supervising physician on staff, Dr. Lutsier, chose to withhold any further administration after being informed of Dr. Papadopoulos' use of ivermectin. On the evening of October 8th, Ms. Stark's condition worsened and she was sedated, intubated, and put on a ventilator. Almost immediately thereafter, Dr. Lutsier was contacted by Dr. Strange, who strongly requested ivermectin continue to be administered in addition to Math Plus protocol. In response, Dr. Lutsier asked Dr. Strange to forward him the relevant literature for which he was relying on, so that he could make a rational and educated decision, which was provided immediately after Dr. Lutsier determined his time would be better spent attending to his patients rather than reading what he referred to as propaganda. On October 10th, ICU nurse Dolores Patel was convinced by Mr. Stark's family to speak with Dr. Strange over the phone. Dr. Strange pleaded with Nurse Patel to administer the Frontline COVID-19 Critical Care Alliance Math Plus protocol. Dr. Patel spoke with attending physician, Dr. Andy Park, and convinced him to undertake Dr. Strange's request. Within 15 hours, Ms. Stark's ventilator was turned down, and Dr. Park and hospital personnel began the process of trying to bring her out of the medically induced coma. On October 11th, Ms. Stark's condition had improved, at this point having only to rely on a nasal cannula. On the morning of October 13th, Ms. Stark's family was informed by Nurse Patel that the hospital had misplaced the ivermectin, but there was no need for concern as Ms. Stark was making great progress. However, Dr. Lutsier once again assumed care of Ms. Stark, and upon learning of the patient's treatment course, chastised Nurse Patel and the medical staff for administering the Math Plus protocol. Dr. Lutsier then administered remdesivir to Miss Stark. Nurse Patel phoned Miss Stark's family and informed them that Dr. Lutsier had assumed care and denied any further administration of the Math Plus protocol. The family was unable to reach Dr. Park, who was volunteering in Sudbury as part of an initiative to help provide critical care to patients battling COVID-19 in rural communities. At 1:27 a.m., Miss Stark's oxygen level began to drop and she became unstable. Within 3 hours, Miss Stark was again placed on a ventilator. The family arrived at the hospital but was denied access due to the hospital's COVID-19 protocols in place. Mr. Stark phoned Dr. Strange and pleaded with her to get involved. Dr. Strange placed several phone calls and emails to Dr. Lutsier, but after 4 unsuccessful phone call attempts, decided to drive to the defendant's hospital in an attempt to manage the situation in person. Upon her arrival, Dr. Strange was denied access to Miss Stark and unable to speak with Dr. Lutsier. Within 6 hours, Miss Stark's chances of survival had dropped to 20%, and Dr. Lutsier informed Mr. Stark that he had exhausted both his course of treatment and COVID-19 protocol in treating Miss Stark. Mr. Stark pleaded with Dr. Lutsier to administer the Math Plus protocol and offered to sign a release, releasing Dr. Lutsier and the hospital and any of its agents and parties acting on its behalf from any and all liability arising from administering the Math Plus protocol to his wife. However, Dr. Lutsier refused to administer Math Plus protocol, and a verbal confrontation ensued outside between Mr. Stark and the medical staff, and security removed him from the building. On October 19th, Dr. Lutsier agreed to the transfer of Miss Stark to Fallview Health, where Dr. Strange was on staff and would therefore be able to assume care for her. However, less than 1 hour after arriving at Fallview Health, Miss Stark died. The questions at issue are as following. What is the requisite standard of care for medical negligence in Canada as correctly applied to this case? Did Dr. Lutsier breach that standard of care in failing to investigate the literature that he was provided with and denying Miss Stark treatment with Math Plus or ivermectin alone? Did Dr. Lutsier's conduct cause or contribute to the harm or injury Miss Stark sustained? Is the hospital vicariously liable for Dr. Lutsier's actions? Justices of the panel, I present to you, speaking on behalf of the plaintiff, Mr. Stark, in today's matter before the court, Yasmin Thompson and Keisha Joseph, and speaking on behalf of the defendant, Dr. Lutsier, and the West Valley Memorial Hospital, Basel Sabalbal, and Ethan Zavarella. We are here today to determine the outcome on trial before the court on the matter between Mr. Stark, Dr. Lutsier, and the West Valley Memorial Hospital. Both the plaintiff and defendant counsel will have 30 minutes each in total, 15 minutes each counsel member to present their arguments to the court, including answering questions from the bench. The plaintiff will present their arguments first, followed by the defendants, and then a 3-minute rebuttal may follow by the plaintiff if they so choose. I will signal to the court via chat when there is 5 minutes left per speaker. The court now invites counsel for the plaintiff to begin.
Good morning, Justices. My name is Keisha Joseph, and along with my co-counsel, Yasmin Thompson, we will be representing the plaintiff in this matter, Mr. Stark. The COVID-19 pandemic put the global population in a state of unprecedented shock. Hospitals continue to struggle with staffing problems, unmanageable numbers of ICU patients, and the overall burden of countless deaths. In such dire and novel circumstances, it is crucial now more than ever that medical professionals commit to meeting the standard of care in order to ensure that as many lives are saved as possible. The plaintiff will be making 3 submissions today. First, that the defendant, Dr. Lutsier, was negligent in his treatment of Ms. Stark. In refusing to collaborate with the patient's family and Dr. Strange, which included refusing to read sound evidence on the proven benefits of administering Math Plus protocol and ivermectin, as well as refusing to administer a potentially life-saving treatment when he had exhausted all other options to save the patient's life, Dr. Lutsier breached the standard of care. Second, the defendant doctor created an unreasonable risk of harm in neglecting to look into an alternative, evidence-based form of treatment that showed visible signs of improvement when administered on Ms. Stark, thus contributing to her harm. Finally, as an employer of Dr. Lutsier, the hospital is vicariously liable for such negligence. My co-counsel will begin by addressing the first submission that the defendant breached the standard of care.
Good morning, Justices. To be successful, a negligence action must meet 4 requirements. The defendant must owe the plaintiff a duty of care. The defendant must breach the standard of care established by law. The plaintiff must suffer an injury or loss, and the defendant's conduct must have caused or contributed to the plaintiff's injury. The first requirement of a successful negligence action is not an issue in this case. Dr. Lutsier acknowledges that he works in the critical care unit where he cares for patients with COVID-19. He oversees all treatment of patients in the ICU and thus owes to those patients, based on their doctor-patient relationship, a duty of care. The second requirement, meeting the standard of care, is the first issue at hand. It was stated in Crits v. Sylvester that every medical practitioner must bring to his task a reasonable degree of skill and knowledge and must exercise a reasonable degree of care. He is bound to exercise that degree of care and skill which could reasonably be expected of a normal, prudent practitioner of the same experience and standing, and this will depend on a case-by-case basis. In this case, Dr. Lutsier stated that the standard of care requires that I inform patient and family when practicably appropriate or allowable. Further, the principles of practice and duties of physicians, which was read by Dr. Lutsier in direct examination, states that collaboration is not only about getting along and treating others with respect, although this is extremely important. It is also about recognizing and accepting the contributions of all other health professionals. The best interests of patients are served when physicians utilize the skills of others, whether they are physicians or health professionals. Physicians should also make a commitment to those others who share this goal to maximize the quality of patients' care. He further acknowledges that the guide is there to articulate the expectations of the medical profession for its members, and that this guide was created by the board that governs Dr. Lutsier, the College of Physicians and Surgeons of Ontario. The defendant admit that the standard of care, in the case of a life or death situation where an alternative treatment was being suggested by a colleague, is the following: engage in a formal discussion with my colleague and then read what they send me in keeping with my duty as a medical specialist. You have to investigate. That would be my duty. That is quoted from Dr. Lutsier in Discovery, yet he failed to do so. Thus, collaboration with the patient's family, as well as other health professionals and physicians, is a crucial aspect of the standard of care for a reasonable physician in Dr. Lutsier's circumstances. In failing to collaborate with Mr. Stark and Dr. Strange by ignoring their requests to both look into and administer Math Plus protocol in the most dire life or death circumstances when all other options had been exhausted, Dr. Lutsier breached the standard of care. The defendant also contends that the standard of care in practicing medicine is to use evidence-based medicine that relates to providing beneficial care and, importantly, avoiding harmful care. Dr. Lutsier claims that remdesivir, the drug that he uses for the treatment of COVID-19, is tried and tested and approved on sound evidence. However, not only did the WHO advise against it for a period of time, but Dr. Lutsier himself admit that he doesn't know for sure if remdesivir is a cause of acute kidney injury, when it very might well be. In regard to kidney injury resulting from remdesivir, he said, "I can't state whether some form of causation exists." Yet he argues that he didn't want Ms. Stark to suffer kidney damage as a reason for not administering Math Plus protocol. However, he concedes that many with COVID-19 have developed acute kidney injury, and many of those could have been treated by remdesivir. When Dr. Lutsier was asked how many studies were conducted on remdesivir, he had no idea. When asked if there was research on remdesivir in relation to its approval, he said no. He was unable to accurately state how many studies have been currently done on remdesivir versus ivermectin with respect to COVID-19, despite relying so heavily on evidence-based medicine.
Counsel, just briefly, my understanding is that the defendant was also part of a larger panel that investigated peer-reviewed journals and created a COVID protocol to be used across the entire organization. Is your suggestion that that was not done, or that the work that was done by that committee wasn't valid?
Thank you for the question, Your Honor. I think the issue here is the standard of care is on a case-by-case basis. So whatever Dr. Lutsier did beforehand, looking into, I think he did say himself that he doesn't personally do research, but they do review the literature. That is what he quoted. And he did so in developing this protocol that you've just raised. However, again, this is decided on a case-by-case basis. And in this case, we're looking at a specific patient with specific circumstances. Despite the fact that they had a protocol in place, what we're going to get into further in the submissions is that sometimes you have to deviate away from a strict standard if someone's life is at stake.
Thank you, counsel.
Thank you. So as I was saying, Dr. Moriarty, expert for the defendant, claims that we need to stop spreading misinformation about ivermectin because people are suffering great damage. When asked why, he simply says, because use of horse dewormer in humans is dangerous. He could not explain Math Plus protocol or ivermectin, showing that Dr. Lutsier is not the only one who's making claims on something that he has refused to look into the evidence on. Dr. Moriarty doesn't have adequate familiarity with Math Plus protocol or ivermectin to treat COVID-19. He talks about how he doesn't need to give a patient vitamin D in regards to Math Plus protocol, yet Math Plus protocol consists of a number of elements that interact together to produce the result that Dr. Strange and Dr. Titchener, expert for the plaintiff, are advocating for. I would like to raise an important statement that Dr. Titchener, expert witness for the plaintiff, stated during discovery. You are, as an ICU physician, left with the choice of watching your patient die or sitting down and reading a few studies and then more if your interest is spiked, no pun intended. Better, the standard of care here is that you adapt to the situation. He had time to treat her, she was young. You assess the patient, speak with the prescribing physician, do your own due diligence, and make a decision. Whether Math Plus protocol or remdesivir should have been used to begin with is besides the point. The point is that a patient was dying, hanging on dearly to her final hours, and there was still one more option left to try, despite Dr. Lutsier arguing that all options had been exhausted. The defendant put what seemed like an inherent bias towards ivermectin that exceeded actual science before the life of a young patient with so much life left to live. This, the plaintiff submits, has surpassed even a minor breach of the standard of care.
Counsel,
If there-
may I interject to seek some clarification on the initial breach of the standard of care being advanced by the plaintiff?
Yes.
You've made the point that Dr. Lutsier breached the standard of care by failing to collaborate because he failed to read the literature being provided to him by Dr. Strange. Is there any evidence that but for that breach, in other words, had he read the literature, that the course of treatment would have been different and the death would have been avoided?
Yes, so as my co-counsel is going to get into in the next submission regarding causation, there was a blatant pattern. And even if Dr. Lutsier, decided, oh, I don't want to look into this, if he had observed this pattern in which every time Math Plus protocol was administered on the patient, she got better, any reasonable doctor would have then looked into the literature when all other options had been exhausted, instead of letting her rot away for 6 days until finally deciding to transfer her over to Dr. Strange, where if transferred over earlier, she could have administered Math Plus protocol. So the point is looking into the literature is the very least you can do to meet the standard of care. And again, whether remdesivir or Math Plus protocol or any of these drugs could have saved her is besides the point. There was a chance left and he didn't take it.
Thank you.
Thank you. If there are no other questions from the bench, I have completed my submissions and my co-counsel will move on to addressing the causation issue.
The plaintiff's second submission is that Dr. Lutsier's conduct contributed to the tragic passing of Ms. Stark. Rather than noting the sudden and blatantly visible improvement that Ms. Stark sustained after the use of the Math Plus protocol, Dr. Lutsier decided to withhold treatment. He did this despite there seeming to be an obvious pattern between withholding the use of Math Plus protocol and ivermectin and Ms. Stark's conditioning worsening. On October 7th, Dr. Papadopoulos administered ivermectin to Ms. Stark while the defendant was not present. Within 11 hours, Ms. Stark's condition had improved greatly. However, upon his return, Dr. Lutsier withheld the ivermectin from the patient on the evening of October 8th. Ms. Stark's condition then worsened, and per hospital protocol, the defendant sedated, intubated, and put the patient on a ventilator, yet Ms. Stark showed no improvement. Then, on October 10th, while Dr. Lutsier was again not present, Dr. Andy Park administered the Math Plus protocol to Ms. Stark. Within 15 hours, Ms. Stark's ventilator was turned down. Dr. Park and hospital personnel began the process of trying to bring her out of the medically induced coma. But on the following day, October 11th, Ms. Stark's condition had improved tremendously to the point where she was only relying on that nasal cannula. However, on the morning of October 13th, the defendant once again assumed care of Ms. Stark. He decided to withhold that Math Plus protocol, choosing instead to administer remdesivir. And unsurprisingly, Ms. Stark's oxygen level began to drop and she became unstable. Within 3 hours, she was placed on a ventilator yet again. And within 6 hours, Ms. Stark's chance of survival had dropped by 20%, and the defendant informed her that he had exhausted all treatments and COVID protocol. Dr. Lutzier tried to argue that Ms. Stark had already entered the pulmonary phase of COVID-19 and that he relied extensively on statistics concerning outcomes for patients who have entered the pulmonary phase of COVID-19. As my co-counsel said, this is besides the point. There was a potentially life-saving protocol and drug on the table, but Dr. Lutzier let the personal bias prevent him from even beginning to consider it. If he was hesitant to continue administering the treatment due to his lack of knowledge on its effectiveness, Dr. Lutzier had the opportunity to review the meta-analysis of ivermectin, Math Plus protocol, and FLCCC's review of ivermectin. Further, Dr. Lutzier's conduct contributed to the harm that Ms. Stark sustained by failing to transfer her back into the care of Dr. Strange at a sooner date. It was not until 6 days past the point that Dr. Lutzier claimed to exhaust all his options that he finally transferred Ms. Stark. He let her deteriorate for a week, which contributed to her harm. After realizing that there was nothing more he could do to save Ms. Stark, Dr. Lutzier had the option to attempt the Math Plus protocol and ivermectin. Mr. Stark even agreed to exempt him and his agents from all liability if the administration of it were to produce unintended results. But the fact that Dr. Lutzier allowed Ms. Stark to deteriorate for those 6 days, despite knowing that he was not going to do any further treatment, not only shows negligence, but further shows that he contributed to the harm inflicted on Ms. Stark.
Counsel, may I ask a question?
Absolutely.
I'm wondering if the evidence for causation with respect to the ivermectin am I correct in my understanding of your argument that you are relying on simply the correlation between the improvement in the use of the Math Plus protocol and ivermectin to prove causation?
Correct. So we're saying that based on the series of events that had occurred with Ms. Stark, that there is a positive correlation in respect to using the protocol and ivermectin with her condition improving, and that the fact that Dr. Lutzier had taken away those protocols from her actually could have contributed to the fact that she ended up doing poorly and eventually passing.
But am I correct that that's the only evidence that you have that you're relying on with respect to causation vis-a-vis the ivermectin?
Correct.
Okay, thank you.
If there are no further questions from the bench, we will move on to our next submission.
Sorry, Counsel, I do have a follow-up question to Justice Sweeney's question. Is there any evidence that the nature of the disease is inconsistent with the patient getting better and then getting worse over time?
There may or may not be. We have not gotten that information as of yet. However, based on what we have been told and based on just the evidence that has happened in the hospital with respect to the protocol itself, we are stating that there is a correlation between the two.
Thank you.
The plaintiff's final submission is that as an employer of Dr. Lutzier, West Valley Memorial Hospital is vicariously liable for such negligence. As stated in the leading case of Yep Riemann, a hospital would unquestionably be liable vicariously for the negligence of a doctor who is a paid employee. There's no doubt that Dr. Lutzier is a paid employee of West Valley Memorial Hospital. This was confirmed during the cross-examination when the defendant was directly asked if he is an employee of the hospital, to which he answered yes. He also stated that he receives a salary from the hospital. Further, the signed physical employment agreement between West Valley Memorial Hospital and Dr. Lutzier clearly states that he is an employed physician and will be working on behalf of West Valley Memorial Hospital. Therefore, the plaintiff submits that the hospital is vicariously liable for Dr. Lutzier's actions.
Counsel, my understanding from your factum is that the only employment agreement or salary for Dr. Lutzier is in the context of being chief or a medical director. Are you suggesting that the care or decisions made about the ivermectin was in his capacity as chief or medical director or in his capacity as a physician?
We're stating that it is both as a physician and as a medical director, as he's in charge of overseeing all actions within his team within the hospital.
Okay, and my understanding of your permission is that in the context where it's a physician providing care, and generally my understanding is that the physician, they're paid through OHIP for their care of patients. The administrative duties as a chief or as a medical director are separate and distinct. So can you help me understand a little bit more about what in the role of chief or medical director, how that kind of correlates with the decisions made for this individual's medical treatment?
Yes, so as a medical director, what we're stating or what we've perceived based on his contract is that because he was in charge of all other actions within his team, even though he wasn't present, he should have been able to have like a say in what went on with Miss Stark's treatment. And even when he returned as a physician, he is still acting as a medical director in our understanding. However, if you would prefer, I can look more into the contract and get back to you.
Thank you, counsel. That's fine for now.
Not a problem. If there are no other questions from the bench, these are our submissions.
Thank you, counsel.
The court now invites counsel for the defendant to begin.
Thank you, moderator, and good morning to all of the justices who have joined us here today and to opposing counsel. My name is Ethan Zavarella, and I am joined today by my co-counsel, Basil Sabalbal, and we will be also splitting up the issues. I will be first addressing the issue of whether our client, Dr. Lutzier, breached the standard of care. Then my colleague, Basil, will be addressing the issues of causation and vicarious liability. I'll start with a little roadmap of where I'm going to go with my submissions. I'll be starting my submission by briefly describing the standard of care in this case. I will then address the decision to not administer ivermectin or MAP plus protocol, and I will discuss whether or not that constitutes a breach. This will require looking at the evidence that Dr. Lutzier was basing his decision on. Then I will address Dr. Lutzier's supposed insufficient investigation of the evidence that was provided to him by Dr. Strange. Finally, I will briefly touch upon the broader implications for the medical community should our client be found liable in this case. So once again, beginning with the standard of care. The standard of care as applied to this case can be found in Stell and Obedkov, and it's described as follows. A physician is bound to exercise a reasonable degree of care and skill as could reasonably be expected of a normal, prudent practitioner in the same experience and standing. If Dr. Lutzier's actions were not in accordance with what could be expected of a reasonable and prudent ICU physician in his circumstance, only then could he found to be negligent. Discussing whether or not there was a breach with the standard of care. Generally, where a doctor has allowed the customary procedures of his profession, he will be shown to have met the standard of reasonableness and thus will not be liable. So it's quite important to inquire what the customary procedures in Dr. Lutzier's position would have been. We believe, Your Honors, that an excellent way to find out what customary practice is for Dr. Lutzier would be to look at the guidelines, the relevant COVID-19 treatment guidelines that guide the conduct of not only top healthcare professionals in Canada, but also globally. Dr. Lutzier relied on the guidelines of reputable organizations such as Health Canada, the World Health Organization, and the Center for Disease Control in the creation of his hospital's treatment protocols. These guidelines are in line with leading authorities in medicine. Our learned friends would have us believe that ivermectin was not chosen as a course of treatment by our client simply out of bias against the treatment. I find this hard to accept, considering that all of these highly reputable organizations, along with all of Dr. Lutzier's colleagues, had made the informed decision not to include ivermectin in their treatment protocols. I find it hard to accept that all of these bodies and all of these professionals would all be harboring the same bias against this particular treatment.
Counsel,
Continuing,
may I interject just to ask you a question about, clearly there is some degree of debate amongst the medical community with respect to the use of ivermectin. We know that Dr. Strange thinks it's highly effective and beneficial, and your client has a different medical opinion with respect to its use. Where does the patient's choice come into play?
Absolutely. Thank you for your question, Your Honor. I would just like to point out that this debate is not as even as opposing counsel would have you believe. If you look to the quality of the research on each side, that there certainly is not parity. Our friends cite the FLCCC, the Frontline COVID Critical Care Council, I believe they go by, and their leading proponent, Dr. Pierre Corey, has had not one, but two of his research papers on the efficacy of ivermectin be retracted. In addition to this, I'm simply basing my position off of what the World Health Organization and other reputable bodies have asserted. And these organizations are very thorough. They review all emerging RCTs in the field. They review also data that has not yet been published. They have an expert team. They're highly respected. So I really, with all due respect, I don't think that this is a case where our client is making a decision that could really go either way. We really do think that the preponderance of the evidence was strongly on the side of abstaining from providing this treatment. And I believe the second part of your question was, where does the interaction with the patient's family factor in? Am I correct?
Yes, does the patient have a choice with respect to her treatment?
So the patient definitely has input as per the Royal College of Physicians and Surgeons of Ontario. But as our client said in the materials, this is not a McDonald's. So the patient cannot come in and simply pick and choose what their course of treatment is. I imagine in any other scenario, were a physician to be presented, a reasonable physician to be presented with a patient who is insisting upon a certain medication that has been widely discredited, he or she would be well within their rights to not entertain that further. I understand that the patient's family, they're clearly in a position of desperation, and I can understand their willingness to cling on to whatever hope may be offered. But Dr. Strange herself has been asked to step down from her position in the critical care unit of her hospital for her insistence on the prescription of ivermectin. In addition to this, there is a case recently that came out just prior to the untimely passing of Ms. Stark, of an Ontario physician who was reprimanded by the College of Surgeons and Physicians of Ontario, in part for his insistence on prescribing ivermectin. So I do truly believe that our client was presented with the decision to continue with sound evidence-based treatment, or to continue with a course of treatment that had been widely discredited and that had seen actually negative repercussions for other members of his profession.
Counsel, I have a question. Sorry to interrupt.
Yeah, absolutely.
There was a period of time where the patient did receive ivermectin, correct? Are you suggesting that the physician that administered that medication to the patient was in breach of the college guidelines and actually providing that medication to the patient?
That is entirely possible. We do know that the doctor who prescribed it was a third-year medical resident. So I'm not super familiar with the medical field, but I do know say in the legal profession, articling students make mistakes all the time. And this is something that's expected. I'm not sure what the exact parallel would be with medical residency, but that is unfortunately not the subject of debate here today. But it is possible that he would have breached the standard of care.
So, and the reason I ask you that, counsel, is this is not a case where nobody was getting this medication. Obviously, it was being administered at this hospital to patients. And in that instance, this sort of goes along the lines of Justice Rob's question. It's clearly an available treatment. So how does the patient's desire to receive that treatment not come into play in this case?
Yes, certainly. So Dr. Luthier has an excellent track record with respect to recovery from COVID-19. And he's on record as saying that had his course of treatment been allowed to continue with untampered, it's almost a certainty that the patient would have recovered. And I understand that ivermectin is something that is used to be treated with COVID-19. We're trying all kinds of different treatment methods, but I'm just simply saying that based on the research that would have been available, it is at best a poor course of treatment, especially with regards to the tested and proven methods that Dr. Luthier had been employing.
I have a question for you.
Yes, absolutely.
I wanted to refer to a footnote in your documentation, footnote number 40, in which you make a reference to a retraction watch.
Yes.
And based upon an article from Retraction Watch, you make this statement that Dr. Pierre Corey is guilty of publishing fraudulent research. I'm not familiar, as a practicing healthcare provider, I'm not familiar with Retraction Watch and its stature within the medical community. Can you please tell me upon what basis you decided that Retraction Watch was a credible and reliable source in which to make the judgment that Dr. Corey is guilty of publishing fraudulent research?
Absolutely. So I could have chosen Retraction Watch. I could have chosen the very hospital from which Dr. Pierre Corey collected his data, who came out with a statement saying that the numbers did not match and they were not even close. So I find it, irrespective of the credibility of Retraction Watch, I find it quite disturbing that someone of Dr. Pierre Corey's capacity and someone who was working at said hospital with access to the numbers would get it wrong in such a serious way. So I do take your criticism that perhaps I could have used a better source. I could have cited the hospital themselves, but I do find it quite shocking that such an error would just be by sheer chance. If there are no further questions, I would like to continue. Okay.
Please go ahead, counsel.
Thank you. So as I have addressed, these leading bodies of medicine, such as the World Health Organization and Health Canada, they're very vigorous. They test all emerging, or they review all emerging RCTs. And our client, Dr. Luthier, is very much aware of this. So in light of that, I would like to address the claim that our client did not sufficiently investigate the research provided to him by Dr. Strange. And by virtue of him failing to dive deeper into that research, that somehow constitutes a breach of the standard of care. I argue, myself and my co-counsel, that by virtue of his familiarity with these various guidelines that are updated and that can be trusted to thoroughly review the literature, there has been no claim made against their reliability. That by virtue of his familiarity with these guidelines that are continuously updated, he would be in a position to have solid evidence to refute the assertion brought by Dr. Strange that ivermectin is effective. Dr. Moriarty is on record in the materials as saying that it would not be a breach of the standard of care by Dr. Luthier to refuse to further investigate the research sent to him by Dr. Strange, should he have, and I quote, solid evidence to refute what she had presented him. I would assert, Your Honors, that this compilation of research by these respected bodies would constitute solid evidence to refute the meta-analyses that were sent to Dr. Luthier by Dr. Strange. That is our position with respect to whether he breached the standard of care by not delving deeper and collaborating further with Dr. Strange. And I believe it was a prudent decision, Your Honors, based on the fact that Dr. Strange is at best on shaky grounds in her profession and has been asked to step down from her position in due to her insistence on prescribing this medication. And lastly, I'm not sure how I'm doing for time. I believe I have 2 minutes, it seems. I would just like to touch on the broader implications of this case should our client be found to be negligent. Your Honors, it is a rare case indeed where a physician is found liable for a breach of the standard of care. These are truly exceptional cases. Less than 2% of cases in Canadian malpractice suits find the physician liable.
Counsel, are you
Yes.
suggesting that we should accept that because statistics suggest that some medical negligence cases are not found in favor of the plaintiff, that means, as in this case as well, we should also not find in favor of the plaintiff?
I am not suggesting that on the basis of that alone you find that, but I'm trying to create sort of the context here.
No, I just understand it's just in
yeah.
your argument you mentioned that backdrop was vital to keep in mind when considering this case. So it seems to suggest that you're asking that we take into account the statistics as to successful or unsuccessful cases in deciding that this might be a case where we also should find in favor of the defendants rather than the plaintiffs.
I would assert that be kept in mind. Yes, it doesn't need to be the primary consideration on which you base your decision, but I definitely do think that it's something worth noting. Our learned friends have made much of the fact that our client did not act as cordially with the patient's family as he could have, but my review of the case law found no cases where failing to act as cordially as a physician could have was a basis for liability. These cases stem from contentious decisions with respect to treatment. And as I've said, his decision with respect to the treatment itself is not highly contentious. He could definitely be faulted for not acting as cordially with the patient's family as he could have. But this, given in light of the rarity of a finding of liability, it seems unlikely that such a basis would amount to that threshold. But lastly, I would just like to say that should a physician who was relying on the best evidence available to him at the time be found liable, I think this really paints a disheartening picture for our healthcare system in Canada. And I think that this will create quite a bit of uncertainty with our physicians in Canada, and it won't be conducive to adequate treatment. If a physician cannot trust in these highly reputable bodies, then where are we to proceed forward in light of that? Thank you very much for your time, Your Honors. I have surpassed 15 minutes. I will now pass it over to my co-counsel Basil. Thank you.
Thank you, counsel.
Good morning, Your Honors. Before we start, I would, just as my co-counsel did there, I'm just going to give a quick roadmap on exactly where my thought pattern is for this argument. I'm going to begin by speaking on the FLCCC and why their recommendations and studies should not be relied upon, along with many other studies suggested by opposing counsels, which I'm sure they've relied on. I will then discuss the issue of causation and how Dr. Lucier's conduct did not cause the unfortunate death of Ms. Stark. I'll also then conclude with discussing the issue of vicarious liability and how West Valley Memorial Hospital is not liable for Dr. Lucier's action in this case. The FLCC is formed by a group of physicians and media professionals who advance the use of ivermectin as a cure-all for COVID-19 and is led by 2 doctors, one of which, as my co-counsel touched on, is Dr. Corey, who was found to have published some fraudulent research, or at least, at the very least, research that was inaccurate regarding the efficacy of ivermectin and Math Plus. Dr. Corey told members of the Senate Homeland Security Committee in December 2020 that ivermectin is a miracle drug against COVID and had profound efficacy in all stages of the disease. Well, as we can see for right now, this is now almost a year, well, past a year later, this is certainly not the case, and there is no cure for COVID-19. He further claimed that if everyone had access to ivermectin, the pandemic would have ended and the economy would reopen. Ivermectin treatment is flawed or inconclusive and is not recommended by Health Canada. A large number of studies had inconsistent patient selection and uneven peer review. Shortly after the passing of Ms. Stark, the American College of Medical Toxicology released a position statement declaring that there's no evidence ivermectin improves outcomes for COVID-19 patients and that the drug may even worsen outcomes. A recent randomized clinical trial with high-risk patients with mild to moderate COVID-19, ivermectin treatment during early illness did not prevent progression to severe disease, and the study does not support the use of ivermectin for patients with COVID-19. I just want to point out that this trial was published in February 18th of this year by JAMA Internal Medicine, which is a monthly publication of peer-reviewed journals by the American Medical Association. This particular journal, Impact Factor, ranks it 7th out of 169 medical journals. There are no Canadian cases that deal with ivermectin in the context of COVID-19. However, a decision by the Ohio court in the fall of 2021 in answering the issue of an injunction should an injunction be granted in forcing a hospital to administer ivermectin to a COVID-19 patient when the hospital's doctors, FDA, CDC, and the AMA, the American Medical Association, do not believe the ivermectin should be recommended way of treatment. In his decision, the judge did not grant the injunction and stated, and I quote, "There can be no doubt that the medical and scientific communities do not support the use of ivermectin as a treatment for COVID-19. He continued to comment that even though there were some doctors and studies that supported the use of ivermectin, the studies that support such use have had, and I quote, inconsistent results, limitations to the studies, were open label studies, were of low quality or low certainty, included small sample sizes, various dosing regimes, and have been so riddled with issues that the studies had to be withdrawn."
Counsel, just a moment. Can you help me understand how the court is to make use of that other decision from the Ohio court? How are we to take that information and apply it to the case here?
Absolutely. Similar to this, there was a significant amount of studies and research that was presented as evidence to His Honor.
So counsel, I guess my concern here is that there's one trier of fact in Ohio who had a number of pieces of information and evidence available to him or her. Right. And on the basis of that evidence, they made a decision. And I guess it sounds as though you might be asking us to imply that because the Ohio court accepted that evidence and made certain findings, we should import the same findings in this case. Is that what you're suggesting?
What I'm suggesting, Your Honor, yes, it's just to take it into consideration. Obviously, you have to make this.
So I understand, but I guess from an evidentiary standpoint, how do I take that piece of information into consideration? Is it because it's a supportive decision that I should take as some sort of binding precedent? Is it because there's evidence I should make use of in that decision? How should I use that decision?
Yes, Your Honor. So I guess the best way, in my opinion, to use it is just to see that in a way, I was looking into any ivermectin or anything that has come to trial or anything that was decided. And I guess just in part of it, the injunction is to show that the courts are not going to force or hold the hands of doctors for making them administer something that they do not believe in or something that the studies have shown to be unproven or unreliable.
Okay, thank you, counsel.
You're welcome. As for the issue of causation, Dr. Lucier testified that had he had Ms. Stark under his care from the very beginning all the way through, he could have saved her. He asserted that he began treating her once the damage had already been done. Without going too much into details with the statement of fact, Ms. Stark tested positive for COVID-19 on October 1st. And given her worsening condition, she was admitted to the hospital on October 5th to West Valley Memorial Hospital. She continued to get worse and was moved to the ICU on October 6th and began treatment with the COVID-19 protocol, which Dr. Lucier, along with the hospital expert panel, as my co-counsel mentioned, had developed. However, on October 7th, at the pleading of Ms. Stark's family, she was given ivermectin by another doctor. It should be noted that the hospital's protocol, again, as advanced by my co-counsel, is a package of literature updated monthly with sound and peer-reviewed research, supported by the CDC, FDA, the WHO, and Health Canada. Further, these guidelines are championed by leading societies in medicine. The hospital's expert panel last updated the package on September 20th. That's a mere days before Ms. Stark was actually admitted to hospital. Dr. Lucier, in his experience with working with COVID-19 patients since the onset of the pandemic, developed expertise in treating patients and can confidently speak, incredibly speak, on the actual cause of Ms. Stark's deteriorating condition. He asserted that Ms. Stark was getting better while on the hospital's COVID-19 protocol, but would then get worse because of the tampering in the treatment by being administered ivermectin. This assertion is supported by the risk of serious adverse effects associated with the use of ivermectin, as mentioned in the credible studies that we highlighted a little bit earlier. There's yet to be a cure for COVID-19. The mere fact that Ms. Stark was displaying signs of improvement does not signify the drug was the cause. It is widely held in the scientific community, and that correlation does not equal causation. It is more probable that Ms. Stark improvement was the result of the proven hospital COVID-19, or it could have been a fluctuation in the COVID-19, as we've known and we've read that it's a lot of COVID-19 patients do go in ups and downs, and it could have been an up. And COVID-19 protocol would have likely saved Ms. Stark's life if it was not tampered with. It has, again, been proven. In considering causation, Justice Sapinka in Snell highlighted that some courts have assumed an unrealistic posture in respect to medical experts to give conclusive evidence that an act caused a given result, and that medical testimony does not lend itself to precise conclusions because medicine is not an exact science. In the present case, it cannot be said conclusively what caused Ms. Stark's death, along with what effects ivermectin or Math Plus had on her. By the time Dr. Lucy started treating her, Ms. Stark had already entered pulmonary phase. The hospital's COVID-19 protocol, when not tampered with, had been effective on patients fitting Ms. Stark's profile, as Dr. Lucy highlighted. However, given the tampering in the treatment with a drug associated with adverse risks and the fact credible bodies condemned the use of this drug for COVID-19 patients, the tampering may have caused Ms. Stark's unfortunate death. As for the claim of negligence for not reading Dr. Strange's literature, Dr. Lucy is privy to a wide array of literature concerning the treatment of COVID-19. He trusts his team, who establishes a scientific back treatment for which he'd been heading in support of medical and authoritative organizations, such as, again, Health Canada, the WHO, CDC, and the FDA. Dr. Lucy, in fact, did open the literature and immediately dismissed it, as he believed the information was not credible and was not prepared to rely on the unproven research to a life-threatening situation. As you see, oh, yes, Your Honor.
Sorry to interrupt you. You've made submissions to explain why it was not a breach of the standard of care for Dr. Lucier to decline providing the ivermectin. What I'm curious about is, how do you explain Dr. Lucier's delay in transferring his patient to Fallview Health, where she could receive treatment from her long-term care provider, especially in the context of Dr. Lucier's own admission that by October 13th, there was really nothing more he could do for her, yet he did not transfer her?
I guess the best way is he believed that by transferring her, he could potentially be putting her life at more risk. He does have a duty to care for his patient. She was under his care. And knowing that if he was to transfer her to Fallview Health under Dr. Strange's care, she would be administering ivermectin, who he believed would definitely cause an adverse effects on her. So he was doing his best in giving the proven and backed treatments for COVID-19.
Mr. Sabalbal, I have another question as well.
Yes, Your Honor.
So referring to a reference in your document, what would appear to be an opinion piece from the American College of Medical Toxicology cautioning against prescribing ivermectin. I have to say that in my 25 years of experience in healthcare, giving ivermectin for scabies and other very benign symptoms like that, I've never observed that any patients have toxic side effects. So I just want to clarify this reference that you use as the basis for which to assert that ivermectin is a toxic medication. Is that an opinion piece by a toxicologist, or is that actually a study referring to injury to patients over a period of time? I'm trying to assess the quality of the evidence that you're using upon which to base your assertion.
Of course, Your Honor. From what we, which opinion? So the one for medical toxicology, or the one from the medical toxicology?
The reference is Diane P. Colello, and I believe that you referenced that within the last 5 minutes indirectly.
Yes, correct. Yeah, it is a research paper to my understanding, and she would have based her opinion or her research on again peer-reviewed articles that have been published. Diane, I believe that she is.
I'm sorry. Do you know that for a fact, or are you conjecturing that?
I'm just speculating on exactly where it was, just from based on the source.
Thank you, sir.
You're welcome, Your Honor. So just to continue, Dr. Lucy just did open the literature and immediately to dismiss this, as I was saying earlier. As we can see that from the actual studies or the actual literature that was presented to him, immediately on the very top, it does say that it holds the FLCCC logo. So right off the bat, he believed that it was not a credible piece of literature because of the recent bad press that they've been getting and the studies that have been shown to be not credible again. He relied on his training, expertise, and experience for the last 2 years in treating COVID-19 patients. And that, in his opinion, would have been much better in order to treat Ms. Stark. This literature was sent to him by Dr. Strange, who had since been asked to step down from her role in the critical care unit at her hospital because of administering ivermectin. Furthermore, she was also issued a warning by the College of Physicians of Ontario for the same reason. Dr. Lusley was not negligent at all in not listening to Dr. Strange or in his refusal to rely on her research. Furthermore, there's no evidence that the transfer would have let Ms. Stark live, and she was under Dr. Lucier's care and felt that he had a duty to treat her. Ms. Stark was advised by our client that Ms. Stark had 20% chance of survival rate on October 15th. Dr. Lucy, in protecting his patient, likely felt that the transfer would most certainly kill her, then that she would be removed from the crucial COVID-19 care that he was given her. West Valley Memorial Hospital is not vicariously liable. In Yepriman, it's a seminal case which establishes vicarious liability in respect to hospitals and their staff, and the fact patterns in Yepriman are similar to the matter at hand. In Yepriman, the hospital appealed the decision of the trial judge in finding liability against it for actions of a physician. The trial judge found the doctor negligent for not administering treatment for diabetes soon enough and in sufficient quantity. As a result of this negligence, the patient went into cardiac arrest, which caused permanent brain damage. On appeal, the court raised the question of whether the hospital undertakes to provide medical care or to select competent doctors who will provide it. The court stated that the public can expect a large public hospital to provide treatment for seriously ill and injured people, but to add no further expectation on the hospital to pay for negligent mistake by a doctor on the medical staff. The court added that public expects a hospital had picked the staff with great care and checked out their credentials. The court implied that the hospital undertakes to select competent doctors that will provide medical care. The hospital, in essence, holds an administrative responsibility to ensure medical services are available. The doctors act are independently from the hospital, and the independence is controlled by their peers. In reaching their decision, the court noted that although the doctor was found to be negligent, there were no suggestions that he was incompetent, or there was no evidence of the lack of care by the hospital's board in appointing the doctor. The court allowed the hospital's appeal and dismissed the action. Just to demonstrate a little bit of a recency and recent decision,
Sorry, Mr. Sabalbal, your time is actually up.
Oh, okay.
Yeah, I'm so sorry.
Oh, sorry, I didn't see that. Okay.
No worries, no worries. The court now invites counsel for the plaintiff to begin their optional 3-minute rebuttal.
We will be taking this time to make a rebuttal. Thank you. So we just wanted to clarify a few things. We did not state that the refusal to use ivermectin throughout the duration of the pandemic is a bias. We are stating that the bias came into play when ivermectin was the last option left on the table. To refuse to try one last option, which has shown visible improvement when someone is on their last legs, that's where the bias comes into play. At issue is not the drug or protocol that the defendant used during the pandemic. Standard of care is decided on a case-by-case basis. May I also remind counsel for the defendant that Dr. Lutzer admit himself that the standard of care in the case of a life or death situation where an alternative treatment was being suggested by a colleague is the following: engage in a formal discussion with my colleague and then read what they send me in keeping with my duty as a medical specialist. You have to investigate. That would be my duty. The defendant stated that himself. So it is hard for us to understand why counsel for the defendant argues that he didn't need to read the literature. And another correction I would like to make to the counsel for the defendant's submissions is that Dr. Lutzer admitted that he did not actually look into the literature. I would also like to point out that ivermectin was sold out at the pharmacy when Ms. Stark was trying to obtain it in her early days of having COVID-19. So it is not as foreign as defendant counsel makes it out to be. Further, Dr. Lutzer himself acknowledged that the drug he advocates for, remdesivir, is also lacking the rigorous studies that counsel for the defendant suggests is lacking for ivermectin. And in regard to your earlier inquiry, Justice Hunter, regarding vicarious liability, I did want to clarify that in the cross-examination, Dr. Lutzer stated that as a medical director of the emergency departments, for which he is employed on a salary basis by the hospital, includes his role to oversee the hospital's emergency teams, which concerns critical care and pulmonary groups. Therefore, in his care for Mrs. Stark, he was acting within his role as employed by the hospital. And again, I just wanted to emphasize that the point is that a patient was dying. She was hanging on dearly to her final hours, and there was still one more option left to try, despite Dr. Lutzer arguing that all options had been exhausted. So again, this woman was on her dying days, her deathbed, and he let her rot there for 6 days when there was another option left to try. And that's their submissions.
Counsel, I just have a follow-up question, and I think your friends have implicitly made this argument that the treatments wouldn't have been effective even if administered. And it wasn't really touched on in either submissions, but I'd like to hear from you how the plaintiffs get around a loss of chance argument from the defendants. Because I think what your friend actually said in her submissions was that this was potentially a beneficial treatment for the plaintiff. So how does that affect the legal analysis that we are to make?
So I think at this stage, no one can say for sure whether further use of remdesivir without the use of MAP plus protocol would have made her better, or whether MAP plus protocol alone would have helped. We can't say that for sure. What we're saying is that there was this correlation, right? And calling it a correlation is even strange to an extent, because there was improvement, right, when it was used. And as soon as it was withheld, that was when she immediately got worse. And that, combined with the fact that for 6 days, he just left her there when he could have transferred her over to someone else's care, it's all just hard to say that there isn't a good likelihood that MAP plus protocol could have made a substantial difference. Did that address your question, Justice Sampson?
It did, thank you.
Okay, thank you.
Okay, great. This concludes the matter of Stark and Lutzer.